Welcome, future barristers. Today, we are absolutely mastering the rules of privilege under the UCPR. Now, if you're prepping for the Queensland bar exams, this isn't just good to know, it's critical. Knowing how to claim and defend privilege when the pressure is on is everything, so let's get right into it.
Okay, so picture this. This isn't just some theoretical exam question. This is a scenario you will face, I promise you, both in your exams and in practice. And your response? Well, it's not just about being right. It's governed by a very strict rule and a super tight deadline that you absolutely have to know.
So, here's our game plan. We're going to follow the logical path of a disclosure dispute, right from that first claim all the way to the final inspection. And along the way, we're going to lock in the key rule numbers at each stage so you can walk into those exams feeling completely confident.
Right, let's start at the very beginning. The foundation of all this is the standard duty of disclosure, and how a privilege claim even enters the picture in the first place.
Here's the crucial point. Your whole obligation starts with your list of documents. You got to remember, Rule 214, Subrule 1A, says you must specify which documents you're holding back under a claim of privilege. This is the first move, and it's the one that sets the stage for any challenge down the road.
Okay, so you've made your claim. Now the other side has challenged it. This is where the pressure really starts to build, and a whole new rule with a very specific process kicks in. Let's see exactly how that unfolds.
This right here, this is the core procedure you have to memorize. No excuses. Rule 213, Subrule 2. It dictates that a challenge triggers a non-negotiable obligation on your part. You must file and serve an affidavit that properly explains the basis of your privilege claim. And the clock starts now. Under Rule 213, Subrule 2, you have exactly 7 days. And let's be crystal clear on this, that is 7 calendar days, not business days. If you miss this deadline, you are in breach of the rules and you're putting your client's privilege in serious jeopardy. So, you've got 7 days to file this affidavit, but what actually has to go in it? And maybe even more importantly, who is the right person to sign it? Honestly, this little detail is often where these claims either succeed or completely fall apart. The rule couldn't be any clearer. Rule 213, Subrule 3, states that the person swearing the affidavit can't just be some random person. It has to be someone with first-hand, direct knowledge of why that document was created. Hearsay, information and belief, second-hand info, none of that is going to cut it. Let's see how this actually plays out in the real world. In international entertainment, the claim completely failed because the affidavit was based on information and belief, basically secondhand knowledge. But then you look at Santas, and the claim succeeded because the deponent had direct knowledge of the purpose behind creating the documents. The lesson here is simple, but it is so critical. To satisfy Rule 213, Subrule 3, your deponent's knowledge has to be direct, period. But what happens in those massive, really complex cases? A case with thousands of documents, created in offices in Sydney, Brisbane, maybe even New York. How can one single person possibly know the facts behind every single one of those documents? This is where the court in Fletcher versus Fortress Credit showed a bit of pragmatism. It recognized that the rules have to serve the ultimate goal, which is laid out in UCPR Rule 5, the just and quick resolution of the case. Blindly enforcing a rule that's basically impossible to follow in a huge case, well, that doesn't really achieve justice, does it? So where does the answer come from? It comes from this classic high court case, Grant versus Downs. And the key insight here is brilliant. Sometimes the documents just speak for themselves. The court can look at the nature of a document, who sent it, who got it, what it's about, to figure out why it was created in the first place. So just like what happened in Fletcher, a judge can personally review the documents to make a call on the privilege claim. But, and this is a big but, be careful. The court in that very same case warned that this is not an excuse for sloppy work. You can't just rely on the judge to do your job for you. Your first duty is still to try your absolute best to comply with Rule 213.
Okay, finally, let's talk about the physical documents themselves. Once a document has been ordered to be disclosed, what are the rules around actually inspecting it? And can you black out certain parts?
This is such a crucial tool in your toolkit. Remember Rule 215. It gives a party the right to see the real thing, not just a photocopy. But this brings up a really common problem. What if a document has some relevant info, but also some highly confidential stuff that's totally irrelevant? This is where masking or redaction comes into play. The key case you need to know here is Cunert v. Williams. You can't just unilaterally get out a black marker and start redacting a document. That's a big no-no. The default position is that the entire document has to be produced. If you want to mask parts of it, you have to apply to the court for an order. The court will then do this sort of balancing act, weighing the other side's need for disclosure against your client's need for confidentiality, always aiming for what is just. All right, we have covered a lot of ground. For your exams, you've got to be able to recall these rules under pressure. So let's do a super quick, rapid-fire recap of the key rules.
You have to burn this into your memory. Rule 214 is your list. Rule 213 is your 7-day affidavit response when you get challenged. And Rule 215 is the right to inspect the originals. Say it with me. 214, 213, 215. Knowing that sequence is half the battle right there.
Because at the end of the day, in practice, and more importantly for you right now in your bar exams, knowing the difference between a successful privilege claim and accidentally waiving it, that could be absolutely everything. This isn't just about knowing the rules. It's about protecting your client to the absolute fullest extent of the law.